In Texas, your driver's license can be suspended before your DWI case is ever decided. And for most people, that's the part they never see coming. I'm Joseph Reese, a criminal defense attorney here in Houston, Texas, and I focus my practice predominantly on DWI cases. When someone is arrested for DWI, their mind immediately goes to court, the charges, and what might happen down the road. But there's another process that starts almost immediately, one that can affect your job, your family, and your daily life long before a judge ever hears your criminal case. It's called an Administrative License Revocation Hearing, or ALR hearing. And today I want to explore exactly what it is, how it works in Texas, and why it matters so much. Here's how this usually unfolds. You're arrested for DWI or BWI. The officer believes you either refused a breath or blood test, or that your BAC was 0.08 or higher, or 0.04 if you're a commercial driver. At the end of that arrest, the officer usually takes your physical license and hands you a form called a DIC 25. Most people are overwhelmed and don't realize what just happened. That form is not just paperwork, it's a notice of suspension, and it acts like a temporary driving permit for 40 days. But if you don't read the fine print, you'll miss what's really important here, and that's that you only have 15 days to request a hearing to prevent the suspension of your license. From that moment on, the clock is ticking. In Texas, you have 15 days from the date you receive that notice to request an ALR hearing. If you miss that deadline, your driver's license is automatically suspended on day 40. No hearing, no second chance, no judge stepping in to fix it later. And this process is completely separate from the DWI case. If you request the hearing on time, your case goes to the State Office of Administrative Hearings, also known as SOA. Typically, they'll give us a hearing within 6 to 8 weeks of making the request. A SOA administrative law judge, not a criminal court judge, decides one thing and one thing only. Does the state get to suspend your driver's license? At the hearing, the state has to prove specific issues, including, did the officer have reasonable suspicion to detain you? Was there a probable cause to arrest you for DWI? Did you refuse a test, or did you fail a breath or blood test by being over the legal limit of 0.08? If the judge finds the state didn't meet its burden, then there is no suspension, and we save your driving privileges. Here's something most people don't realize. ALR hearings are often a gold mine for discovery. Your lawyer can subpoena the arresting officer, question them under oath, and lock in testimony about the stop, field sobriety tests, and the testing procedures they used. That testimony doesn't disappear. There's a permanent record of that. We can request a transcript from the ALR hearing and use that to help on the criminal side. I've seen ALR hearings expose mistakes that completely change the direction of a case. We once had a client facing a third DWI, and at the ALR hearing, we were able to uncover sworn testimony from the officer that invalidated the traffic stop. So even though our client was over twice the legal limit, we were able to get his third DWI completely dismissed based on the testimony that we locked in at that ALR hearing. In that particular case, the officer was claiming that our client was all over the road, failing to maintain a single lane of travel. And after watching the video, it became apparent that he only left his lane of travel by a couple of feet, just momentarily, with no other cars around him. Under Texas law, there has to be not only a movement away from the lane, but something that created a hazard to other motorists. And let's be real, losing your license isn't just an inconvenience. It means trouble getting to work, higher insurance rates, problems for commercial drivers not being able to earn a living, relying on family for basic transportation, and serious consequences if you're caught driving with a license suspended. For many people, the license suspension hurts before the criminal case ever does. So if you've been arrested for DWI in Texas, understand this. You do have rights, you have options, but you also have deadlines. The 15-day ALR window is one of the most important moments in the case. I'm Joseph Reese, a Houston DWI defense attorney. If you want help protecting your license and building your defense from the very beginning, reach out to my office. We have a very high win rate on ALR hearings and have saved hundreds of driver's licenses over the years.